Hello, Live viewers. Welcome to Courts Today. Let us dive into the important legal headlines of the day. The Supreme Court, while quashing an FIR against a Congress MP over a poem, has said that judges must protect freedom of speech even if they don't like what was said. The Gujarat High Court has delivered a split verdict on temporary bail sought by Asaram Bapu in a rape case. Kunal Kamra has moved the Madras High Court for transit anticipatory bail in Mumbai Police FIR over the satire video. The top court has rejected a plea to register an FIR against Justice Yashwant Verma over the recent cash row. The Supreme Court has directed payment of 30 lakhs compensation within 4 weeks for manual sewer cleaners' deaths in metros in the last 3 months. Regarding farmers' protest, Punjab government today informed the Supreme Court that protester Dalewal has ended his fast and that the national highway had been opened after clearing the protesters. The Jammu and Kashmir government has exempted stamp duty on property transfers executed through gift deeds between blood relatives. And the Kerala High Court has rejected pleas seeking probe into bribery allegations against Chief Minister Pinarayi Vijayan and his daughter Veena. I'm your host Urvashi Chauhan, bringing you the important legal updates of the day, quick, crisp and to the point. Watch till the end, and if you find this update valuable, don't forget to like, share and subscribe to our channel because your support keeps us going. Starting with an important update where the Supreme Court has today quashed an FIR registered by the Gujarat Police against Congress Rajya Sabha MP Imran Pratapgarhi over his Instagram post featuring a video clip with the poem Ek Khoon Ke Pyas Se Baat Suno in the background. A bench of Justice Abhay Oak and Justice Ujjal Bhuya, allowing the petition filed by Pratapgarhi, observed that no offence was made out. In its judgment, the bench underscored the importance of protecting the freedom of speech and expression and reminded the courts and the police of their duty to uphold the rights of persons expressing unpopular opinions. To read an important part of the judgment, it says free expression of thoughts and views by individuals or groups of individuals is an integral part of a healthy civilized society. Without freedom of expression of thoughts and views, it is impossible to lead a dignified life guaranteed under Article 21 of the Constitution. In a healthy democracy, the views of thoughts expressed by an individual or group of individuals must be countered by expressing another point of view. It further says that even if a large number of persons dislike the views expressed by another, the right of person to express the views must be respected and protected. Literature, including poetry, dramas, films, satire, and art, make the life of human beings more meaningful. Criticizing the Gujarat High Court for refusing to quash the FIR here, the Supreme Court observed that the courts are duty-bound to uphold and enforce the fundamental rights guaranteed under the Constitution and to step in and protect them. The judgment also makes pertinent observations for the police force who were overzealous in lodging the FIR. The court observed that for the offence under Section 196 of the Bharatiya Nyaya Sanhita, the spoken or written words will have to be considered based on standards of reasonable, strong-minded, firm and courageous individuals and not based on standards of people with weak and oscillating minds. In the next update, the Gujarat High Court has delivered a split verdict on the temporary bail plea of Asaram Bapu, who is serving a life sentence after being convicted in a 2013 rape case. A division bench of Justice Ilesh J. Vora and Justice Sandeep N. Bhatt differed in their opinions, with Justice Vora willing to grant 3 months bail while Justice Bhatt dissented. As a result, the matter will now be placed before the Chief Justice for referral to a third judge. The Supreme Court had earlier granted Asaram interim bail till 31st March on medical grounds. During the hearing of this matter, his counsel had argued that as per the doctors, his health condition required 90 days of Panchkarma therapy. However, the Gujarat government had opposed the plea, stating that his condition was not severe enough to warrant bail. The complainant's lawyer also had contested the request, pointing out that Asaram's blood pressure was normal and that temporary bail was unnecessary. Let me tell you, Asaram was convicted in January 2023 for raping his female disciple at his Ahmedabad-based ashram. He was sentenced to life imprisonment under multiple sections of the Indian Penal Code, including for rape, unnatural offences and criminal intimidation. The final decision on this temporary bail will now depend on the third judge assigned by the Chief Justice. Stay tuned. Stand-up comedian Kunal Kamra has approached the Madras High Court seeking transit anticipatory bail in connection with the FIR lodged against him at Mumbai recently over his alleged remarks against Maharashtra Deputy Chief Minister Eknath Shinde. A zero FIR was registered against Kamra under the Bharatiya Nyaya Sanhita for public mischief, defamation, etc. by Shiv Sena MLA Moraji Patel. The FIR was later transferred to Khar police station in Mumbai. Though Kamra had not directly taken the Deputy Chief Minister Eknath Shinde's name, the party workers alleged that he had called Shinde a traitor while referencing to his split from the Shiv Sena. Kamra is a permanent resident of Villupuram town in Tamil Nadu and thus claims Madras High Court has jurisdiction. An urgent mentioning of the case was made before Justice Sundar Mohan today. While mentioning the matter, Kamra's counsel submitted that the comic has been receiving death threats after the show. Also, you already know that offended by Kamra's remarks, a group of Shiv Sena workers had also vandalized Mumbai's Habitat studio where the comedian had performed the show. 12 people were arrested in connection with the violence that had erupted and were subsequently granted bail. Moving ahead, the top court today refused to entertain a petition seeking registration of FIR against Delhi High Court Judge Justice Yashwant Verma over the alleged discovery of illicit cash at his official premises. This petition also challenged the in-house inquiry being conducted by a 3-judge committee as per the Chief Justice of India's directions. A bench of Justices Abhay S. Oak and Ujjal Bhuyan dismissed the plea filed by senior advocate Matthews Nedumpara, calling it premature. According to the bench, after the in-house inquiry, various options would be open. The CJI could order an FIR or refer the matter to the Parliament, but today was not the time to consider this petition. Advocate Nedumpara had in his plea questioned as to why no FIR was registered on the day the cash was found, why no seizure report was prepared, and why the matter was kept a secret for a week. He contended that the investigation should be conducted by the police and not the judiciary, and that an in-house inquiry is not a substitute for a criminal probe. However, the bench reiterated that the process should be allowed to conclude first and then legal options remain open. When Nedumpara raised concerns about public perception, Justice Oak responded that the common man should be educated about Supreme Court's judgments on in-house procedures. The court ultimately refused to admit the petition and dismissed it, declining to revisit past judgments on the issue at this stage. The Supreme Court has criticized officials from Delhi, Kolkata, Hyderabad and Bengaluru for submitting misleading affidavits regarding the ban on manual scavenging and hazardous sewer cleaning. The court noted that the new affidavits were cleverly worded to create a false impression of compliance. It has warned that failure to file proper affidavits in the next hearing would lead to suo moto contempt proceedings. A bench of Justices Sudhanshu Dholia and Arvind Kumar is hearing a petition seeking an end to manual scavenging. The judges reiterated that the practice must stop. Additionally, the court directed metropolitan authorities to pay 30 lakh compensation to the families of workers who died due to hazardous cleaning in the last 3 months. The compensation must be paid within 4 weeks. Earlier, the court had noted that civic bodies including the Delhi Jal Board, Kolkata Municipal Corporation and Hyderabad Metropolitan Water and Sewage Board failed to explain how such deaths occurred despite their claims that manual scavenging had ended in their cities. In another important update, the Punjab government today informed the top court that it has cleared the protesting farmers from the Shambhu and Kinnauri borders near Haryana and cleared the national highway for free traffic movement. Advocate General of Punjab Gurminder Singh also informed the bench comprising Justices Surya Kant and N.K. Singh that Jagjit Singh Dalewal, the veteran leader of the protesters, has ended his hunger protest today, which started in November last year. The farmers started their protest in February last year, raising demands such as statutory protection of minimum support price. The national highway borders were blocked by the Haryana government to prevent the march of farmers to Delhi. The protesters then chose to clamp at the national highway borders. The bench today also refused to entertain a contempt petition filed against the Punjab authorities for clearing the protesters in alleged violation of a status quo order passed by the Supreme Court last year. The bench said that it was the court which has been prodding the government to open the highway and that the contempt petition was misconceived. Following this, the contempt petitioner chose to withdraw it. Also, the court today dropped the contempt proceedings initiated earlier against the Punjab Chief Secretary and DGP for not taking steps to hospitalize Dalewal, who was sitting on fast then. In a significant move to simplify property transfers within families, the Jammu and Kashmir government has announced a waiver of stamp duty on property transfers executed through gift deeds between blood relations. The decision aimed at reducing financial burdens on families was issued through a notification under Section 9A of the Stamp Act 1977, citing public interest as the primary reason. The exemption applies strictly to transfers between close family members. For taking the benefits under this exemption, blood relations have been explicitly defined to include father, mother, brother, sister, son, daughter, grandfather, grandmother, grandson, and granddaughter. To avail this benefit, both the giver and the recipient must submit at least 2 identification documents as proof as specified in the official order. This waiver will come into effect from 1st April 2025, ensuring that eligible transactions executed on or after this date benefit from the exemption. By eliminating additional costs in family property transfers, the decision is expected to make the process more accessible and less financially stressful. The notification has been circulated to all relevant revenue and tax authorities to ensure smooth implementation. And lastly, the Kerala High Court today dismissed 2 revision petitions challenging vigilance court orders that refused to initiate corruption probes against Chief Minister Pinarayi Vijayan, his daughter Veena Vijayan, and other public officials. Justice K. Babu ruled that the criminal revision petitions stand dismissed. Let me tell you, the first petition, initially filed by Girish Babu, who has since deceased, accused Veena Vijayan and her company Exalogic Solutions Private Limited of receiving illegal payments from Cochin Minerals and Rutile Limited in exchange for favors related to mining interests. The plea also named several political figures, alleging that they had accepted bribes. The petitioner claimed that CMRL made substantial payments under the pretext of software services, but no actual services were provided. The Vigilance Court had dismissed the complaint, citing a lack of prima facie evidence. And the second petition, filed by Congress MLA Matthew Kozhalnadan, also sought to inquire into the alleged payments made by CMRL to Exalogic Solutions to secure political favors. However, this petition too was dismissed. With the High Court upholding the Vigilance Court's decision, no investigation will now proceed against the Chief Minister or the other accused based on these complaints.